Good day, everyone. Welcome to our report, Article 3, Bill of Rights, Section 21. Reporters are Marky Gabriel, Precious Namok, and Priscilla Levine. Section 21. No person shall be twice put in jeopardy of punishment for the same offense. If an act is punished by a law and an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act.
What is double jeopardy? Double jeopardy is the prosecution of a person twice for the same offense.
When there is an existence of double jeopardy requisite under present law and jurisprudence, the accused is placed in double jeopardy if the following conditions are present. He has been previously brought to trial in a court of competent jurisdiction, and you are a valid complaint or information. He has been arraigned, he has been convicted or acquitted, or the case against him has been dismissed or otherwise terminated without his express consent, and he is being charged again for the same offense. What are the classes of double jeopardy? For the same offense under the first sentence, the protection is against double jeopardy for the same offense and not for the same act, provided he is charged with a different offense except if the act is punished by a law and an ordinance, in which case conviction or acquittal either under shall constitute a bar to another prosecution for the same act. For the same act, second sentence contemplates double jeopardy of punishment for the same act, and it applies although the offenses charged are different, one consulting a violation of a statute and other of an ordinance.
Section 22. No ex post facto law or bill of attainder shall be
What is ex post facto law? An ex post facto law is the one which, operating retrospectively, makes an act done before the passage of a law, innocent when done, criminal, and punishes such act, or aggravates a crime or makes it greater when it was committed, or changes the punishment and inflicts a greater punishment than what the law annexed to the crime when committed, or it may alter the legal rules of evidence and receive less testimony done or different testimony from what the law required at the time of commission of offense in order to convict the offender.
Characteristic of ex post facto law. First, ex post facto laws relate to penal or criminal matters only. Civil interests are protected by non-impairment clause. Second, they are retroactive in their operations. And third, they deprive person accused of crime of some protection or defense previously available to their advantage. What is a bill of attainder? A bill of attainder is a legislative act which inflicts punishment without a judicial trial. Example is, Brian is a member of the Communist Party. Brian applies for a job as a teacher at her local elementary school and is refused, based on this statute. Members of any subversive group, including the Communist Party, cannot hold public office nor teach for a public institution. Brian could attack this statute as a bill of attainder. Its provision targeting members of a communist or any other subversive group punished by eliminating career opportunities. The member targeted are punished without a trial or any adjudication of their rights. Thus, the statute allowed the legislator to impose a sanction without a trial in violation of the institution prohibited powers.
What is the purpose of prohibition against bill of attainder? The prohibition against the enactment of bills of attainder is designed as a general safeguard against legislative exercise of the judicial function, trial by legislative. A person should not be rescued of punishment in the single violation. If punished by law and by ordinance, an act, the punishment or acquittal under which either here will be a hindrance to other persecution for the same act. The reason why there is a law on ex post facto law or bill of attainder is to protect the human rights of the people. Therefore, no ex post facto law or bill of attainder shall be enacted.